The Supreme Court on Wednesday will hear its most important case in decades on the First Amendment rights of students, and ultimately is expected to decide whether young people are free in the era of social media to post vulgar, cruel or racist comments about their teachers, coaches, classmates or school. At issue is whether social media posts are off-campus speech, beyond the control of teachers and schools. It is the rare case whose outcome could affect every public school in the nation, but only if the justices succeed in drawing a clearer line between the rights of students and the disciplinary authority of school officials. Since 1969, the High Court has said students retain their rights to freedom of speech at school, including famously by wearing black armbands to protest the Vietnam War. But that landmark decision in Tinker versus Des Moines was a compromise. It also spoke of affirming the comprehensive authority of school officials to control conduct, and to forbid speech that could lead to substantial disruptions or disorders on the school premises. With the rise of social media platforms such as Twitter, Instagram and TikTok, the question is whether provocative posts that circulate quickly through a school community are beyond the reach of school officials. Judges and lawyers cited instances in which students falsely portrayed a principal as a sex-obsessed pedophile, aided cheating by posting exam questions and answers in advance, encouraged harassing an unpopular classmate or threatened to kill a teacher. The case before the court this week arose from a Pennsylvania girl's F-word rant on Snapchat after she learned she did not make the varsity cheerleading team. She posted a photo with her middle finger raised and repeated, F, school, F, softball, F, cheer, F, everything. Her Saturday afternoon post made its way around the school, including to her coaches. They suspended her from the junior varsity team, citing the team rules that said cheerleaders must show respect for the school, coaches and other cheerleaders, and avoid foul language and inappropriate gestures. She and her parents filed a suit in federal court, alleging a violation of the First Amendment and seeking an order that would reinstate her to the team. A federal judge agreed, ruling that her brief outburst did not cause a substantial disruption at school. When the Mahanoy Area School District appealed, the Third Circuit Court in Philadelphia broke new ground with a broad ruling in the girls' favor. We hold today that Tinker does not apply to off-campus speech, that is, speech that is outside school-owned, operated or supervised channels and that is not reasonably interpreted as